Hi, good morning and welcome back. My name is Ariana Kelly. I'm a barrister at King's Chambers focusing on court of protection and social care and healthcare law. I'll pass over to Sophie Allen, who may be muted still.
I just muted myself. It's a good start. Hello, everyone. I'm Sophie Allen. I'm a barrister at King's Chambers, and one of the areas of law that I practice in is the Court of Protection as part of that team.
And so we're here to talk to you today a little bit about this slightly more specialist area of law. And I'll just put up a brief PowerPoint. Sorry, I hope I'm not at risk of PowerPointing you out too much on this, but we will just stick that up to help guide us. Right. So the first question that most people ask us about our area of law is what actually is the Court of Protection? It's something that appears in the newspapers from time to time, almost always in a very negative light, and almost always talking about some horrible thing that's happened in the Court of Protection, often referred to as Britain's secret court by several of the broadsheet papers. To give you one example of that, the Telegraph, this is a Telegraph story from 2016, the terrifying tale of how Britain's most secret court imprisoned a grandmother. So we'll be talking to you about some of the public perception of the court protection, but also some of the nuance that goes behind some of these cases, because it can be really interesting to learn what actually was happening and what led to that overall outcome in the case. This was a case about an elderly, vulnerable man who had had dementia for a number of years. He had entered into a relationship with a woman who had taken him out of his home area of Devon to come and live with her in her house in another part of the country. Some of his family members and social services had concerns. They didn't think this was the right thing for him. They thought he should go back to Devon. And as the evidence in the case started to mount up saying that actually he should go back to where he was living before, this woman took him to go and live in Portugal. She brought him to a care home and she left him there. Because of the way that the law works out, she was the only one who had the right to take him out of that care home in Portugal. So there was a court case that went on within the Court of Protection for a couple of years to try to get her to sign papers to bring him out of Portugal and bring him back home, because it was the view of the court that that was the best thing for him, that he would be the happiest and best cared for if he did end up coming back to England. But she wouldn't do it. The court told her that it would send her to prison unless she agreed for him to come home within 7 days, and she still wouldn't do it. So the court went ahead and eventually sent her to prison. This is not to inveigh at all as to what the right or wrong thing was in this case, but it does bring up some of the complexities of this. You had this very vulnerable man who wasn't able to make these decisions for himself. And the question was, when you had this dispute between social services and some members of the family on one side, this woman he was in a relationship with, and other members of his family on the other side, who actually makes that decision about what's the best thing for him and what's right?
So, as Ariana said, if you're having a conversation with someone and they ask you what you do and you say that you're a barrister, the first question is often, what kind of law do you do? And if you say that one of the areas of law you do is court of protection, the second question is very often, well, what's the court of protection? And the short answer to that is that the court of protection is a court that makes decisions on behalf of people who can't make decisions for themselves because they lack the mental capacity to do so. And the Court of Protection's got a very wide-ranging power in that regard. It can make almost any decision that any person could make for him or herself. So, for example, the Court of Protection can make a decision about where someone should live, what kind of care they should receive. The Court of Protection can make a decision about who they should have contact with and how much contact. The Court of Protection can make financial decisions on behalf of people, who should be responsible for someone's money, what should be done with that money. And the Court of Protection can also make health decisions for people who lack capacity to make their own health decisions. So you can make a decision about whether someone has medical treatment, whether they have a serious operation, whether they have a particular type of healthcare. And you can get very important and very difficult decisions that arise out of that. And Aria's going to tell you about one of those now.
So this is a headline, which I have to say is an essentially accurate statement of what happened within the Court of Protection, and probably less sensational than some of the others. This was a case that just happened very recently of a young man in Barnsley. He was 34 years old and he had had significant abdominal issues, including problems of having intestinal blockages. And when he was in his early 20s, he was advised to have what's called a colostomy bag put in place to help relieve that. This is essentially something where you have a bag put in surgically to your intestines so that what would otherwise be defecated would end up within the bag, and it ends up outside of your body and helps to prevent those sorts of blockages from happening. Some people do find them difficult to live with, and this man found it extremely difficult to live with. He felt that this bag had essentially ruined his life. He had stopped his employment. He had become depressed. He stopped having girlfriends because he was extremely embarrassed about the bag. He didn't want anyone to know that this was what's happening, and had really felt that this had ruined his life in a profound way. Certainly not everyone feels that way, but this man did. And so in consultation with his doctors when he was in his 30s, he agreed that the bag would be taken out and he would try to just get other kinds of treatment to deal with his problems. However, unfortunately that didn't work, and within a couple of days he ended up with an intestinal blockage and then sepsis, and ended up extraordinarily unwell and had to be admitted into intensive care in order to prevent him from dying of the sepsis. He had made a written statement a few months prior to all of this happening, saying that he did not want to live with the colostomy bag. And if treatment being offered to him involved this irreversible stoma, this irreversible colostomy bag putting in place, he didn't want it, even if that meant that he would die as a result. However, at the time that this application came before the court, he was unconscious in ITU because he was so unwell. And the main treatment which was being proposed for him was that he would have this colostomy bag put in place in order to relieve it. However, he had been absolutely adamant that this hadn't been what he wanted. He did understand what he was doing. He did understand that he would die. But what he wanted was for it was not to be treated in this way, because he didn't feel that that was a life that he wanted to have. It's certainly not a decision that everyone would make, but in the court of protection looking at this, where he was unconscious and unable to make that decision for himself in the time, the court looked very closely to what he said that he wanted for himself. And in those circumstances, the court said that he'd been very clear. He had lived with this for 10 years. He knew what he wanted, and he didn't want to keep living that way. So to that end, they said that he shouldn't be treated in that way, even though it probably would have saved his life. There are some decisions that are seen as being so fundamental that no one else can make them for you. And the Court of Protection is actually barred from making them as a matter of law. Two of the big ones on this are whether to get married or whether you can have sex with someone else. That is never a decision that the court could make on your behalf in any circumstances if you lack capacity. All the court can decide is whether you can make that decision for yourself or not. There was another case, this time The Guardian writing about this one, that got a lot of headlines last year for a comment that a judge had made in a preliminary hearing when he talked about whether a married couple, had a fundamental human right to have sex. Now, the way that he had specifically framed it was what had drawn quite a lot of attention in this, is referring it as a man's fundamental human right to have sex with his wife. The background of this case is really interesting, though. At the time that this case came before the court, this was a couple that had been married for 27 years. They had had a daughter, and by all the reports, the husband had been extremely supportive and caring of his wife. The wife was very happy living in the family home. She didn't want to be anywhere else. All of their family members and the wife herself really expressed the husband as the touchstone of the wife's life. She didn't want to be separated from him. However, the wife had a very serious global learning disability. And when people started making inquiries about it, it was queried the extent to which she really understood what sex was, whether she understood that you could get pregnant, whether she understood that you could get sexually transmitted infections. And they analyzed this very closely. And there was a question which was brought before the court as to whether or not the wife actually understood sex well enough to consent to it. Now, one of the reasons that this was really tricky was that this was in the context, as I say, of someone who had been married for many years, someone who had been having sex, someone who had had a child already. And what was being proposed, at least in some corners, was whether or not the husband and wife would have to be separated as a result of this decision to prevent her from potentially having sex without having capacity to do it. It's a really tricky area, and it's certainly one that's been evolving in case law. But I think it just goes into showing that these cases are often very complicated, and looking at what the right solution is for this woman is always a very, very difficult one, because removing her from the risk of having sex without consent, which is obviously a very, very serious risk that everyone's taking very seriously, involved her taking her away from the person who had really been the focus of her life for the last several decades.
So you've heard a lot of references already to mental capacity. What is mental capacity? In a nutshell, having mental capacity means having the ability to make your own decisions, or the ability to make a particular decisions. So someone might lack the capacity to make decisions if they have an illness, such as, for example, dementia, or perhaps a brain injury or a learning disability of some kind. But it's very, very important to remember that just because someone has dementia or a brain injury or is unwell mentally in some way, that doesn't necessarily mean that they lack capacity. We have what's called the presumption of capacity. And the presumption of capacity means that everyone is presumed to have capacity unless it's established that they don't. And if you want to say that someone doesn't have capacity, it's for you essentially to prove that's the case. Now, how you test whether someone has capacity or not to make a particular decision, it is very often not very straightforward. There's essentially a fairly strict set of criteria about whether someone understands the relevant information, whether they can remember it, whether they can weigh it up. And it's always very important to remember as well, when you're talking about capacity, that people can make bad decisions, they can make unwise decisions without lacking capacity. And if you make a bad decision within reason, I guess, within the law, and you have mental capacity to do so, you're entitled to do that. It's really important and fundamental to our society, isn't it, that people should have autonomy and should be able to make their own decisions, even if those are decisions that not everyone, or that most of us, wouldn't make. And Arianna's going to tell you about a case where that issue came up.
Assuming I'm actually able to operate my computer, yes, I am. This was a very interesting case that actually got quite a bit of media attention back in 2015. And there were several different newspapers that had picked this up, even to the extent of hounding this woman's family and her young children. I believe one of her youngest daughter was 11, and people had been doorstepping them to try to get more information about this case. It was a person that it was strongly suggested probably would have been a recognizable name in many circumstances. She was 50 years old. She had been described as having the life of a socialite. She had been married many times. She described in her own terms as living the high life throughout her life. And she had come to a time in her life when she was suffering from some illnesses. She had attempted suicide, which had left damage to some of her internal organs, and she required kidney dialysis. In this case, the doctors did think that it was actually quite likely that she would be treatable. She would need intensive dialysis. She would need hospital care, though it was possible that she wouldn't recover fully. She didn't want it. She was quite clear that she didn't want it. She felt that she had lost her, and she, as she described it, her sparkle. And multiple members of her family also came forward to say that they understood what she meant, that this is not the life that she would have wanted to lead. She referred to it as she didn't want to be living poor and without this sparkle and without the sort of high life that she had so savored. And so to her view, it was better not to be treated. It was better simply to let go and have this disease overtake her, which it eventually did, and she passed away. But what the court focused in on in this case was actually her capacity. It didn't make a best interest decision that it was right for her not to be treated. It made a decision that she had the capacity to take this decision for herself. She fully understood what was being proposed. She understood that she could get better. She understood that it wasn't necessarily going to work, but that she might simply have the dialysis and be able to move on living her life as a relatively healthy person. But she didn't want it. And it was that aspect of it that Sophie's describing, her ability to understand that information, her ability to use and weigh that up, that was what the court really looked at and saying, actually, I'm not taking your autonomy away. you can make that decision for yourselves. I should also just say we've actually had a couple of good questions in from some of the participants, which I have finally managed to open the chat frame and actually look at. I think on the first question, the one about the sex capacity case, this is actually the case, if you're interested in reading it for any students out there, it was the case of Tower Hamlets, NB and AU. And what the court actually looked to was that you should be looking at sex capacity in potentially a person-specific way of saying, actually, in the context of her relationship with her husband, she may have the capacity to understand what sex is, even if she doesn't necessarily possess all of the other things that you would normally expect a person to have, the other information that you would expect a person to have. We've also got another question of, and this is perhaps for actual one I can answer pretty quickly, is who funds these cases? Are they publicly funded? Many court protection cases are legally aided. Local authorities and health bodies are often parties in these as well, so that's often a party. Some people have to fund them for themselves if they don't have legal aid, but for many court protection cases, and especially around health and welfare, there is public funding available to do it. There's another question as well, is do you sometimes think about the moral consequences about what you advocate for, and does it sit uneasily with you? Yes, I think, I think we think about the implications of this a lot. And I think, as a barrister, certainly, you always have to think about the broader picture. You're obliged to give legal advice, but I think you often end up working with the clients to talk about the overall situation and sometimes the wisdom of litigation, in addition to just the legal merits of the case, and enter into those discussions. It is ultimately a choice for the client to make as to what case they want to run and pursue, and you are bound obviously by your instructions in the case, but it is, you think about it a lot. It really, I mean, certainly for me, and I'm sure Sophie can opine on this as well, but I mean, there are a lot of these cases that really sit with you. There's a lot of these cases that keep you up at night. I've certainly had many where people have been calling me at midnight on a Saturday because something is happening right now and they need to do something, and you take the call because if you can help, you certainly want to.
Yes, certainly. And I was just going to say, in relation to the question about whether you sort of think about the cases in a moral way, of course, it does come down to, as with any area of law and being a barrister, and you may have heard about this already if you've looked into the law, or maybe from other panelists, but there is still something called the cab rank rule. And in terms of people who do criminal law, they're often asked, well, how do you defend someone who you think is guilty? And the answer is the cab rank rule, and that is, unless there are certain circumstances, unless you're professionally embarrassed, if someone instructs you to make a point in court, you have to make that point. And it still comes down to what your instructions are. And so ultimately, if your instructions are something you don't necessarily agree with, then you have to make that point in court. But as Ariane has said, if something that makes you uncomfortable or that you don't think it is right, you're within your rights as well in talking to your clients to talk about the implications of that, and whether they might want to change their instructions. And still, there's quite a lot of cases coming in. Sorry, Ariana, go on.
Oh no, and I was going to say, certainly with public authorities, I think they often want to have that conversation because I think they do want to actually talk through what the implications of that will be, because I think it's, sometimes it's not enough just to be legally right if you do it in a way that seems embarrassing and isn't actually the consequence you want to have. So I mean, it's a discussion, and I think, as Sophie says, you're bound by your instructions, but I think it's often a discussion you have. The questions I think I can answer very quickly on this is the court of protection is not about children. It is about adults. And the other question, I can forward in the answer to this, the name of the sex capacity case. And I think actually one interesting point is the question of how cases like this get started. The lady who was married for 27 years. Often what you have in these scenarios is a safeguarding alert is raised in relation to a person, or it's often through social services that you have this come in. For that lady, she had actually been having a conversation with her dentist, and her dentist had raised the question of, this lady doesn't really seem to understand much of what's going on in terms of sex at all, in terms of a discussion they'd had. I don't know the full context because the cases don't always reveal that. But the dentist had raised a concern with social services and they had started the investigation. We do have a couple more things to cover in the talk, so I'm just going to set aside some of the questions just to make sure we actually cover this, because this is a very interesting bit that I'll hand over to Sophie for.
Yeah, as you said, actually, there's lots of really interesting questions, and what we can do at the end is we'll come back to it and try and answer as many of those as possible at the end. Let me just close down my chat feature so I can actually see my slides. Okay, so what's deprivation of liberty? Issues of deprivation of liberty come up all the time in the Court of Protection. It's a really important issue to consider and be aware of. The European Convention on Human Rights says that everyone has a right to liberty, and you probably know that, and that no one is to be deprived of their liberty unless there's a legal process to detain them. And the European Convention on Human Rights also says that if you are being deprived of your liberty, you've got a fundamental right to challenge that. Now, usually you think about being deprived of your liberty as being detained or arrested or put in prison. That would be the usual. But in terms of people who've got access to the chat, can anyone think quickly about who else might be detained? Who do you think might be detained?
If anyone wants to do fastest fingers, mental health,
Oh,
psychiatric
yes, okay,
hospitals.
great.
Excellent. Thank you. Abuse victims, dolls. Oh, you guys are on fire. This is great.
Yeah, absolutely. Okay, so we've got all the answers there. Absolutely. People might be detained in hospitals, in psychiatric hospitals. People might be detained in care homes. People might be, someone's mentioned dolls, so obviously if they were that, and that is a deprivation of liberty, effectively. Yes, so we've got all the answers. And what kind of settings you can be detained at is really important. So if we're thinking about the deprivation of liberty, can I just say, Ariana, I think my screen's stuck. I don't know.
Sorry about that.
No, it's fine. Do you want to go on to the next one?
Is it
not doing it? Oh, brilliant. Okay, so if we're thinking about what a deprivation of liberty is, we think about Mr. P. So Mr. P is 38 years old. He has cerebral palsy. He has Down syndrome. He needs 24-hour care. He'd lived with his mother until very recently, but she'd become unwell and she wasn't able to look after him anymore. So at that point, he'd moved to another property. He'd moved to effectively a private property, a normal house that we'll call Z House. And he lived there with two other men. There were staff that worked there. They worked there all through the day. And one staff member was there at night. Mr. P and his housemates did various activities during the week, but he was always supervised doing them. The staff would stop him from doing anything they didn't think was safe. He wasn't allowed to leave the house on his own, but there was no indication that he was unhappy or that he wanted to leave. Mr. P exhibited some challenging behaviours, but that was part of his condition anyway. It wasn't reflective of him being unhappy. Everyone who was involved with his care agreed that this was a really good care package for him. So the question for you, and given the answers to the previous question, I think you'll know the answer, but the question for you is, was Mr. P being deprived of his liberty? Is Mr. P being deprived of his liberty? What do you think?
All right, let's hear it. Yes. Okay. yes, no.
Many
okay.
Yes.
There's a mix. I like it. Okay. There's we're getting about 50-50 yes, no so far. To some extent, yes. I like that. No, he has freedom. No. Okay.
Okay, interesting.
It was and a very interesting answer actually. It was for his own good, which was exactly what the Court of Appeal said.
So thank you very much for your answers. This situation I've just set out there, this was a situation, a case that's a very, very well-known case in the Court of Protection. That's known as the Cheshire West case. And Mr. P was one of the individuals involved in the Cheshire West case. And the Cheshire West case went all the way to the Supreme Court, so the highest court in the country, to decide whether Mr. P and some other people who were involved in the case were living in a deprivation of liberty. And what the Supreme Court said about that is that ultimately it doesn't matter if someone isn't objecting to being somewhere. It doesn't matter if they're happy. It doesn't matter if it's a normal home, and it doesn't matter if it's for their own good, because they can't keep themselves safe. If someone is under what's termed continuous supervision and control, and they're not free to leave, and Mr. P wasn't free to leave and he was supervised, then you are detained. It's a deprivation of liberty, and you've got a right to appeal that. And the state has to be very careful about authorising these kind of deprivations of liberties, because it's a real infringement on someone's autonomy. And the slide that's up now has got some statistics on it. Detention and deprivation of the Mental Capacity Act, which is one of the ways you can be deprived of your liberty. You can also be deprived of your liberty of the Mental Health Act as well. But detention and the Mental Capacity Act is a very significant form of state detention. And the figures there, so the most recently available figures show that over 200,000 people are deprived of their liberty at any one time in care homes and nursing homes and hospitals. But in addition to that, there's an awful lot more people who are living in situations like Mr. P within the community, in normal houses, in normal homes, who are also being deprived of their liberty. Now, just by way of thinking about the size of that population, does anyone want to have a guess at what the prison population in England and Wales is?
Any guesses? We've
Any
only got a couple
guesses?
minutes
Just
left.
pick a figure
What do you
out.
think?
60,000.
60K?
Yes,
700K?
Oh, someone's got it right.
Somebody.
Yeah, someone got it right.
I think, well, award to Jenny Cooper, who
Yeah.
nailed it nearly on the head there. So
It's about 80,000. It's about 80,000. Okay, just pass back to Ariana now.
And I apologize, I have to shut down because I now can't see the slides if I keep my chat windows open, so I'll have to rely on Sophie to tell me. So very, very quickly, because I think we've got about 2 minutes left. Another area of law we practice, which is also going to be wrapped up a bit in the public law talk that you'll be getting today, is around health and social care law. The Court of Protection primarily looks to questions about what decisions should be made on behalf of a person who can't make decisions for themselves. Health and social care law is much more about what options should be available to the person. It's very, very, very often around questions of people who have disabilities and what sort of care, healthcare or social care, in order to help them do things in their lives, they should be entitled to, and it's part of public law. Very, very quickly, the case that went all the way up to the European Court of Human Rights was the case of Elaine McDonald, which was a really interesting case about a woman who had a difficulty with her hip. She had a weak hip, and she also had a health condition which caused her to have to go to the toilet about 3 or 4 times a night, every night. Her local authority had initially commissioned a sitting service to have someone with her at night to help her get out of bed and in and out of bed in order to go to the toilet. They then decided they could save about £25,000 a year by giving her incontinence pads and just having her honestly wee herself in bed rather than doing that. They saved an enormous amount of money, which was probably then just absorbed into the health and social care budget. But for Mrs. McDonald, she was saying that she was forced to be an incontinent person, which in reality she wasn't. She was just a person who needed some help in her life, and that this had really taken away her dignity and that she was entitled to that level of care. And the case was really about that push and pull of what she was entitled to live a life that didn't make her feel that she was without dignity and make her feel that she was able to look after herself in a way that she would want to, versus the right of the state to save really a lot of money every year in not looking after her that way and looking after her in a much cheaper way. It is that push and pull that often animates those questions in health and social care, because you can provide people with an enormous amount of care, which helps them live a really good life and lets them do the things that they want to do. But it costs money and the budgets aren't infinite. And there's that, it's really the question of the individual versus the group and how those decisions should be made. And often the judicial reviews are around enforcing that person's right to get the care that they need in that scenario. So I'm cognizant, I think we have about 1 minute left. And I think we were talking about, we were just going to try to give you a brief day in the life of what we do. Right now, we're largely working from home, so a day in the life is a little bit different because a lot of it is going up to our attic and doing video hearings. But I think in terms of thinking about who do we work with, and because were some of the questions that we raised, we work with public bodies, we work with local authorities, we work with health bodies, we work with family members of people who lack capacity. We work with people who lack capacity, often through their litigation friends, who may be advocates, who may be family members in their lives, and who may be the official solicitor. The issues which arise in our cases are very often about where people should live, what kind of care they should get, and also sometimes these more extreme issues of whether or not a person should receive medical treatment that keeps them alive, who they should have contact with is something that very, very often comes up. Hearings are something that we do quite a lot of, but really it is just one part of our job, because a massive part of it is really trying to do that understanding, doing the case law research, keeping yourself up to date on the law, and making sure that you've read what's often a lot of information about the person to understand the complexity of people's lives and help to prepare your case for court. I think I sometimes refer to it as the court bit of it is almost the tip of the iceberg. All the work that you do in order to understand the case and be ready to go to court is the whole rest of it under the water. And always lots of reading. Handing over to Sophie briefly.
Well, we've run out of time, so I won't trouble you too long with this, but we just thought it might, again, just the idea of what we might do in a day, because I think it might be quite difficult to imagine what a barrister does every day in this area of the law. And I think the one thing to say is that every day, and well, at the moment, every day is the same, because Ariana said it's going to your office and looking at your screen. But pre-lockdown, I gave you a pre-lockdown day. There's a real day from before COVID. And that was just a Friday for me. There was usually a lot of traveling. So I got trained to Middlesbrough. I had an advocates meeting, which is a meeting before you have with other barristers, essentially, and other solicitors before a hearing, where you try and narrow down your issues, see if you can reach an agreement. I got to Middlesbrough. I did a case which we'll call PL, which was about a lady who was living in an extra care facility who was unhappy with where she was living. I then did a case that we'll call KF, that was the grandson of an elderly gentleman who was essentially alleging that the local authority were financially abusing his grandfather. I then got the train back, and you have to be very careful about working on a train because you don't want to breach any confidentiality, but I may have done a bit of work on the train for the following week and looked at some papers for the next week for a conference. And then on that particular day, I got home about 5:30.
Sophie, I'm going to ask, just because I've had this from two different people, is how much time do you spend on your feet and how much time do you spend in court, would you say?
Well, on feet and in court is the same thing. I think in a normal week before all of this, I would probably be physically in court maybe 3 days, and other days would be paperwork, conferences, phone hearings, phone meetings, and lots of reading.
And now, being cognizant that I think we're now 3 minutes over, we're handing over to Johnny Ward and Simon Arnold. So thanks. I'm sorry we weren't able to answer quite all of the questions, but thanks so much for your attention.
Thank you very much for your listening to questions. Okay.